Former President Jacob Zuma spending the night in the Escort Correctional Facility. In the days leading up to his incarceration, his lawyers filing a last-minute application to stay out of prison at the Pietermaritzburg High Court. The former president also petitioning the Constitutional Court to rescind his sentence. So with both of these hearings yet to be concluded, what is the likely outcome for the former president here? Joining us now for some legal analysis is Advocate Modidima Mannya. Thanks very much for your time this morning, Advocate Mannya. It's great to have you with us on the show. Let's begin with what an incredible moment this is in our country's history. You know, some would say on the one side of the argument, a victory for the rule of law. How do you read it?
Yes, good morning, Michelle and your viewers. I think sometimes we are too hard on ourselves. And let me just give you a few examples. You know, in 1997, late former president of Zambia, Kenneth Kaunda, was arrested and put in the maximum security prison. In the Maldives, the former president was also arrested by order of the court for alleged money laundering. Just about 2-3 weeks ago in Mauritania, the former president Aziz was arrested. In Bolivia in March, the former president was arrested. So I think sometimes we get too hard on ourselves. The arrest of the former president Zuma is part of what is happening globally where such circumstances warrant. Of course, in our case, it is the first time. And of course, the Constitutional Court said itself that this was some bit of a novelty or exceptional set of circumstances that occurred in the country. But indeed, the rule of law is the rule of law. Our Constitution is clear. Everyone is equal before the law, and it doesn't matter. And as I said, even the Chief Justice, if the Chief Justice were to be in contempt of court or break the law, according to that Constitutional Court judgment, she or he will not be immune from being arrested.
What did you make of the last-minute movements from the legal team for the former president over, I would say, the last 12 hours or so? So we got word at around 6 o'clock last night that a letter had been written to the Constitutional Court asking it to stay the warrant of arrest, at least until that decision is made in the High Court in Pietermaritzburg on Friday. And of course, the rescission application is also still pending next Monday. Were you surprised by just how late his legal team left it to actually make a move to petition the Constitutional Court?
Well, Michelle, I can tell you, if you were to be in trouble with the law, you would want your lawyer to try whatever miracle or trick in the book to get you off the hook. And I think desperate times call for desperate measures. But let me indicate that I found it a bit intriguing because it does happen that when a judge reserves judgment, they often would say, look, don't do anything until I deliver my judgment. And I think Judge Mguni decided not to do that. And therefore, you said with a situation where the warrant remains in force and could be executed, and the execution thereof remains lawful up to this far. And until that warrant is set aside, it will continue to have force and effect.
I mean, if you were on the side of the former president's legal team, is this the strategy you would be using?
Well, certainly not, bearing in mind that, you know, I think there's always been a controversy, and I cannot fault anybody because whoever, you know, applied their legal mind would have considered certain factors. I don't know what those factors would be. But ordinarily, you would have expected that they would have approached the Constitutional Court. I think there's a further complexity in this matter, is the confusion that is created, which suggests that the Constitutional Court is actually going to review its decision as in the form of an appeal. That is actually not the case. The decision of the Constitutional Court is final. If it has to be rescinded, there are limited grounds to have a judgment rescinded. One of such is when there's a patent error, or there's an error common to the parties, or the judgment was obtained by fraud or some other thing. Now, I don't necessarily think that all those requirements are there. If you remember, the Constitutional Court, even in its judgment, has said that they took the extraordinary steps to afford former President Zuma his procedural rights, to the extent that they even invited him to say, tell us what we should do with you if we find you to be in contempt. And one of the major complaints that the Constitutional Court raised was his attitude and response. Instead of filing papers, of course, you remember that former President Zuma went on rampage in the public domain, attacked the court, attacked the judges, sent letters. Even up to yesterday, there was that measure of defiance. Now, one of the difficulties in our system is that you do not disrespect the court, disobey the law, and go and run to it for protection. But with regard to writing a letter to the Constitutional Court, obviously the Constitutional Court is a court. You know, you can imagine if everybody was to write a letter, the whole process that has been prescribed to handle matters would fall apart. So writing a letter to the Constitutional Court to ask directives on staying a warrant, which matter is not even before the Constitutional Court, was a bit of a false start in my view.
And I suppose it presupposes that there would be some kind of special treatment, because you or I would not be writing a letter of that nature to the Constitutional Court.
Well, you can write, but I can tell you it will mean nothing.
Yeah.
It doesn't matter. I think one of the things that we must start to discount and discourage the public from institutionalizing in their minds and perceptions is that there is a place where special treatment is sold. You know, to suggest that the Constitutional Court would give special treatment before it even considers a matter is a bit of a dangerous proposition. So, but we must also not discourage people from taking effort to see how they think they can vindicate their rights. But there are defined processes, Michelle, in the court. If you want to approach the court for any order, you need to file a formal application, not a letter.
Yeah, absolutely. I mean, you've just said as well that the Constitutional Court, in how it's conducted the case of the former president and this issue around defying a summons from the court to appear, from the state capture inquiry to appear before it, and a directive from the Concord to adhere to that summons, it did, as you say, take extraordinary steps to afford the former president his procedural rights. You also say that a decision by the Constitutional Court is final, and it handed down that decision last Tuesday in delivering a guilty verdict for contempt of court and a 15-month jail term to go with it. And yet then the court opens its doors to this rescission application on the 12th of July.
Yes, and that is because there's a procedure where if an order or a judgment is made against a person, in the absence of that person can approach that court to rescind that judgment or order. And that should not be confused with whether the court will grant it. The court may actually not grant it. And I personally think in the circumstances, the chances of a rescission seems to be far-fetched in this case.
And of course, on the flip side of that, before we get to the 12th of July, there is also that pending decision for the High Court in Pietermaritzburg. We're told that decision will be handed down tomorrow. I'm sure you were watching those virtual proceedings where all of the cases from the side of the state capture inquiry and the former president were made to Judge Mnguni there at the High Court in Pietermaritzburg. Certainly from his body language, I mean, of course we can't read, we're not body language experts, but it didn't appear that he was being convinced of the issue around jurisdiction.
Look, I think it would be firstly dangerous to even, and you did correctly say, to, you know, try and use his body language. You know, one of the things that you must bear in mind is that it is very uncomfortable to sit for such a long time listening to argument. So if from a human point of view, you will see some movements that you may just easily misinterpret. But I think what has happened, the issues were extensively ventilated. And I think he has given some hints on what he thinks, and you could have seen that from the questions that he was asking. But you must not be misled, because sometimes you go into court as a lawyer, and the judges are on you and asking all the difficult questions. And when you think, look, I've lost it, in fact, they sought clarity, and you get surprised to get a ruling in your favor. So people must not be confused by the theatrics in court. What we must do is just to wait for Judge Nguni to deliver his judgment, and he will deliver a judgment.
What do you reckon, though? Did Advocate Dali Mpofu succeed in arguing the issue around jurisdiction, or indeed did Advocate Tembeka Nkukaitobi succeed in making his argument for the state capture inquiry that it's impossible for the High Court to intervene in a decision from the Apex Court?
Look, the question is not who was good or who was bad. That is an irrelevant consideration. The function and the job of the lawyers in court is to assist the court to reach a conclusion. The question is whether Judge Nguni is going to make a finding on whether he has jurisdiction or not. It may be that the arguments were flawed, but it is his responsibility as the judicial officer to apply the law correctly. So the fact that the lawyers may have argued this way or that way is actually immaterial. They were there just to assist him.
Yeah.
He will ultimately have to find the law and determine what the correct legal position is. So it's a bit dangerous to say, well, I think this one argued better, I think this one was battling. It's immaterial. It is the judge who's going to ultimately make a decision.
Yeah, and he will make that decision tomorrow. Advocate Modidima Mannya, it's a pleasure talking to you. Thanks very much for joining us on what is an incredibly important morning here in South Africa. Just some 6 hours or so, shall we say 5.5 hours, since the former president has been at the Escort Correctional Facility. Former President Jacob Zuma now taken into custody to begin that 15-month jail term as imposed by the Constitutional Court after it found him guilty of contempt. It's certainly the big story on our radar this morning.